When we talk about remedies then, so always talks about rights and remedies. Now rights, we look at people's rights, we've done that throughout this video. We looked at the key issues, but remedies are about what happens at the end and what they're going to be claiming for. Now usually it's going to be dead easy, they tell you a sum of money and you just say, right, they're going to be claiming for that because it's loss of profit and so on, and £800 they've lost. But you need to be careful, right? So you need to make sure you say if it's liquidated or unliquidated damages. You need to explain that sometimes, you need to look at remoteness of damage. In contract law, the same as in tort law, you're only going to have to pay for damages that are foreseeable. You also have to prove that the damage has happened, right, to some extent. The quantity of damage it has made an impact on your life. There is also a duty to mitigate. It's not something that comes up often in contract law, but you could argue that in certain situations they might mitigate them by, if they've lost out memorabilia through misrepresentation, they might have sold it to someone else. That mitigates the losses and you make up the difference. It might be nominal or speculative damages, so the court may award them if they feel it's relevant. Again, you're not a judge in this situation, you're not going to be making those judgments. What you do need to do though is look at categories of recoverable loss. What can people claim for? Well, if you lose a loss of a bargain or expectation at the ending of your contract, there's usually an amount, but you could list that. What about you lost a profit? But remember, it's got to be foreseeable profit. What have you lost a chance? The chance of becoming an actress. Like Chaplin and Hicks was awarded 24% of the overall actor's fee because she lost a 12 in 50 chance of getting the job. So 12 out of 50 that went for the audition got the job, so she got 24% chance. So 24% of the wage she might have got, that was her remedies. Or we might suffer a reliance loss. Okay, so pick out which you think is best and link the amount which is in the scenario. It gives you the answers within there, and if not, list these. But remedies don't stop there. Okay, so specific performance has come up, injunctions has too. I would just need to be careful with this. Okay, so specific performance means that you make somebody do something, but oddly it isn't available for contracts of personal service or employment. So if you try to use specific performance to make somebody complete a job for you, you can't. So that's just how it works. It's also not going to be awarded where court can't supervise performance because the court capacity can be very difficult for them to make people do something, or where performance is impossible. The thing doesn't exist anymore, or the thing is gone. So specific performance usually comes up with a smaller problem question, and you would look to the reasons for it. But nevertheless, it might be in certain circumstances the right thing for them to do. Injunctions. Now again, you're mostly going to have prohibitory injunctions and mandatory injunctions, not interlocutory, so I've left that out. A prohibitory injunction orders a defendant not to do something in breach of contract. So they say you're about to breach a contract, you can't do it. Like Warner Brothers and Nelson, you can't go and work with that company under contract for another one. A mandatory injunction requires a defendant to reverse the effects of an existing breach. And rescission means the parties have returned the positions they're into before the contract was made. So instead of with contract law, the aim of damage is to put the person in the position would have been at the end of the contract, so if all obligations were fulfilled. Instead, rescission says, right, we're going to wipe all obligations and we're going to pretend like the contract never happened, there's no obligations in as much as they can. So this is of course for misrepresentation and economic duress, because you want to say the contract never existed and put everything back to the position it would have been in.